All right, so we are here with Wayne White from the AIAA. Thank you very much for joining us today.
I'm glad to be here. I should immediately note that while I am here at the conference as a representative of AIAA, everything said in this interview are my own opinions.
That's a good disclaimer.
And not the opinions of the American Institute of Aeronautics and Astronautics.
Well, thank you very much again for joining us. And what we wanted to talk about today was a lot of your ideas and proposals, specifically regarding space law and space policy, and one in particular. So can you tell us a little bit about how you got involved doing that and what sort of legislation you've worked on?
Well, thank you. I have been interested in space law since 1980 or so. And when I applied to law school, I wrote my personal statement about space law. And I ended up choosing to go to the University of California, Davis Law School because they have a large collection of space law books, and they had a couple professors there that were interested in space law. And so I wrote my law review article about real property rights in outer space. It turned into a document the size of a small book, and I didn't get it done till about a year after I got out of law school. And so, believe it or not, the long academic version of that article has never been published. But in 1997, I presented and had published a shorter version of the article. I presented it at the International Institute of Space Law meeting in Turin, Italy, and it got published in their annual colloquium volume. Prior to that, I had written mining law for outer space and salvage law for outer space, which are both published articles. And so for all of my professional career, I've written about and spoken about space laws that would encourage commercial development of outer space. And so after all these years, a couple of years ago, I started working on comprehensive legislation that would enact real property rights, mining law, salvage law, and other provisions that would specify the authority of private operators of space facilities. So maybe just a little discussion of the philosophy of this. One reason I was drawn to space law is that it's a new area of the law where you can look at what's already been done in the law and you can try to make it better. You can look at the laws that have worked and you can look at the laws that haven't worked, and you can try to put together new laws for outer space that are consistent with our legal system but designed to achieve certain purposes, like the promotion of commercial activity and the facilitation of human settlement of outer space. And so I came up with this comprehensive, I haven't written all the legislation, but I have a PowerPoint that's pretty detailed that goes through all of it, and I've written about 20% of the legislation. So this would be a comprehensive U.S. federal statute, a set of statutes that would provide a legal framework for commercial activity and human settlement of outer space. And it would include real property rights, property law, salvage law, the concept of a safety zone, the authority of private space facility and spacecraft operators. Also, I've taken an initial stab at which government agencies would have authority over certain legal aspects of the law. We have, in the State Department, there is an office that maintains the U.S. Registry of Space Objects. And so part of my proposal for this legislation would say that the registry office at the State Department would add a couple of extra columns to their registry, and in one column they would indicate if a space object was available for salvage. And in another column, they would list whether whether the owner of the space facility had received title to the area where the facility is located, real property rights. And it would also list mining claims. So I guess there would be 3 additional columns on the registry. I think it's maybe easiest to start with the issue of space debris. This law would address a number of issues. In addition to the objectives that I stated earlier, promoting commercial space activity and human settlement, the salvage part of the law is designed to encourage companies to salvage space objects and either recycle them or refuel them. So it's both mitigation of space salvage and servicing of satellites to extend their useful life. With salvage law, it would be directly analogous to ocean salvage laws, and the industry, the prospective industry of space salvage would operate in a similar fashion. So you would have salvage contracts. A company that has a satellite that doesn't have any more station keeping fuel, or a satellite that's non-operational. The company that owns that satellite can advise the State Department, we'd like to make our satellite available for salvage. And so then they list it on the registry, and the registry office would have contact information. Typically the insurance company would be advised that you're putting the satellite up for salvage, because they also typically have some interest in the satellite. And so then the way the salvage contract works is that the salvor, the company that salvages the satellite, they get a pretty high percentage of the value of that satellite. If they capture the satellite and they go and they recycle it or they refuel it, they get a pretty high payout for doing that. But the company they effectively sell that satellite to the salvage company, and so they get some money, and depending on the circumstances, the satellite insurance company might also get some money out of that.